Good morning, colleagues. May I congratulate you. I think you chose a very interesting panel to follow. I would like to start now, because otherwise I have to say good afternoon, and we don't want that. We are still a morning panel. I have distinguished speakers here with me. If I can ask you to take your seats so that I can start to introduce them. This panel is actually one of the will address one of the key questions that a citizen might have towards law enforcement when it comes to data protection. And this key question is, what do you have actually about me? It is about data subject rights. The citizens asked law enforcement authorities about access to his and her rights. My name is Daniel Drewe. I'm the data protection officer of the Europol, the European Law Enforcement Agency. I guess I've been asked to chair this panel because my unit at Europol deals with around 500 data subject requests per year that we receive from citizens that would like to know whether Europol process holds data about him or her. And maybe I have the possibility later on in the discussion also to share with you some of the practice examples that I could give to you out of my perspective as a data protection officer. Data subject requests, we had not only a huge data protection reform with a lot of different legal instruments that are in place now, but we also had, with this huge data protection reform, we also had changes in the area of how a citizen can make use of his right to get access to his and her data. It is clear that if we talk about the general data subject access rights, and then specifically about the situation where a citizen asks the police, that there are challenges, obvious challenges for law enforcement, because law enforcement has on the one side to balance between the proper achievement of the law enforcement tasks, and on the other side also to ensure that the data subject can exercise his or her right towards law enforcement. I mentioned already there are a lot of new legal instruments. They all entail a provision on data subject rights. So we have the GDPR, the Law Enforcement Directive, the Modernized Convention 108, the Europol regulation, which has also a new article on data subject rights. And last but not least, the regulation, the EU regulation now applied to the EU bodies and agencies. Also there you will find the article on data subject rights. What was the whole goal if you look at the changes regarding data subject access? At Europol, for over 2 decades, we handle data subject access requests. Still, we got a new article in this. There is now a new and extended catalog for the data subjects. They get more information than before, and more information means also they should get more control over their own data. Does this work in practice? We will get the answer today with a fantastic panel that I would like shortly to introduce to you. On the far left, Clara Guerra from the Portuguese Data Protection Authority, a former supervisor from Europol, by the way, not anymore, but a former supervisor in Europol's joint supervisory body. Next to her, we have Anna Moscibroda from DG Justice, working on data subjects, request access rights, and as a policy officer in the area of data protection. Another, I would nearly say another former supervisor of Europol, was not really true, but I have here with me, and we are very grateful to this, Hielke Hijmans, Senior Policy Advisor at the Center for Information Policy Leadership, ex-EDPS official, I can say so, and an expert in the area of data protection, in particular when it comes to data protection and law enforcement. And last but not least, Professor Vagelis Papakonstantinou, Vrije Universiteit Brussels, alternate member of the Greek DPA, so also related to supervision of law enforcement, inclusive Europol, and member of the Greek GDPR Law Enforcement Directives Implementation Committee. Welcome, thank you very much. My planning for this panel, of course, I know that there will be a lot of questions, is I would like now the speakers for their introductory statements. And afterwards, I will hand over to Clara for the further moderation of this panel. Anna, can I ask you to start? Thanks.
So hello, can you hear me? Okay, very good. So the title of this panel is Law Enforcement and Data Subject Rights, and the question that that panel is supposed to answer is the new legal framework a step forward? So I think it's a good idea maybe to recall the new legal framework, especially in relations to Law Enforcement Directive, the new legal framework for data subject rights. So just to give you a very brief overview of what the Law Enforcement Directive is doing in relations to data subject rights, and especially of what is actually different from GDPR. So first question always to ask is, what is the scope of applications of Law Enforcement Directive? One very clear, I think, improvement comparing with the past is that the Law Enforcement Directive is now applying to the domestic processing by law enforcement authorities, which, well, previously we did not have a European framework covering that sphere. On the other hand, we have to bear in mind the line of delineations between GDPR and between the Law Enforcement Directive. And for the Law Enforcement Directive, that's something that we need to remember about the delineation is the personal scope that is the directive is applying actually to the processing by law enforcement competent authorities, and the material scope. So that is for the purposes of prevention, investigations, detections, and prosecutions of criminal offenses, executions of criminal penalties. So those two elements have to be fulfilled together for the Law Enforcement Directive to apply. And in that sense, it's also, one of the general comments would be that both GDPR and the Law Enforcement Directive, they have their own respective scope of applications. They should be respected, meaning that if the scope of applications of Law Enforcement Directive is met, the conditions are met, it is the Police Directive that should in principle apply. I mean, the act transposing the directive. In terms of actual rights, the Law Enforcement Directive is quite similar to GDPR in terms of the catalog of rights. So we have the right of information, the right of access, rectifications, erasure, and right of restrictions. There is no right to portability, no right to be forgotten, of course. What is also there is the possibility for the member states to provide in the legislative measures the restrictions to those rights. Now the language of those restrictions is unified along the various rights, and there are conditions. That is that the restrictions needs to be necessary, proportionate, measure in a democratic society with the due regard to the fundamental rights and legitimate interests of the natural persons concerned. And there are listed bases for those restrictions. Those bases of those restrictions are narrower and targeted to the law enforcement needs. They are narrower than bases for the restrictions in GDPR. Now, the very specific issue of the directive is that when and if member states are opting to actually provide for the restrictions of data subject rights, the member state have to provide for the possibility of exercising that right via data protection authority. So in that sense, there is a new feature occurring. The first default, let's say, way of exercising the data subject rights under the Police Directive is to go directly to the data controller. However, again, if the member states have provided for restrictions of those rights, the data subject has an option, has to be provided with the option to exercise those rights also via data protection authority. And the same goes also for the restrictions of the information that is provided to data subject rights about their rights being restricted. So The Law Enforcement Directive provides for the possibility when, for instance, right of access is restricted, there is in principle obligations to provide the answer and to a data subject, including the reasons for that restrictions. There is, however, also possibility given to the member states to provide for the restrictions of that information in those cases where providing the information about the reason would in a way cancel the reasons of imposing restrictions in the first place. That leads to the situations that in certain cases the data subject might not be actually provided with a very meaningful information about processing of his personal data in a given system, and might be provided with what we sometimes refer to as a neutral reply. So reply along, we can neither confirm nor deny that your data is actually being processed. In those cases, the data subject rights, and that it's also for that reason that data subject rights have been provided under the Police Directive with additional safeguards, which is a possibility to go and exercise the rights via data protection authority, who in a way exercise the rights on behalf of the data subjects. Another feature of the specific feature of the Law Enforcement Directive is, well, it's Article 18, which provides for the possibility to regulate the rights of the data subjects in national legislation, which basically regulates the procedures in the realm of the criminal law. And I will come back to that specific point a bit later on. And now, so that's a brief overview, or let's say the main features or main structure of the data subject rights under the Police Directive, of the specific features of the exercise of the data subject rights. Now, the Police Directive is already in place for some time. The deadline for transposition of the Police Directive, there was in May last year, and well, that deadline of the May last year was not met but by quite some number of the member states. So as you might remember, back in June, the Commission has issued the letter of formal notice for non-notification of the measure transposing the directive to as many as 19 member states. Since June until now, there was some progress in terms of the transpositions by the member states, which is, of course, the good news. And as of today, we know that there is 21 member states who have the Transpositions Act in place. Out of that number, 20 member states have actually notified to the Commission. Commission has actually issued last week the reasoned opinion against 9 member states for the lack of notification of the Transposition Acts. So, and then, as you know, there is a deadline of 2 months for those member states to react, and the case may eventually go to the Court of Justice on that issue. If I have a few minutes more, maybe 2 minutes more, so I'll be very brief then. I wanted to share a very general, preliminary, let's say, observation relating to transpositions that have been notified to the Commission. Again, it's not a very complete picture because we don't have a complete picture yet, and it's a very, very initial, let's say, observations on a very superficial level. But what I think we can say is that, well, most of the member states, or all of the member states that have so far notified, they do provide for the restrictions of the data subject rights. It's not very surprising to see. All of those member states also provide for the possibility for the data subject to exercise those rights via data protection authorities. There would be, however, quite interesting to see how that specific right is phrased, and we see the differences in languages between the member states, and that right might, let's say, be broader, more narrower. What else from the interesting points? In terms of actually providing for the restrictions of data subject rights, we see that there are member states who basically follow the language of the directive itself. Well, my general comment on that would be that, of course, that might not necessarily suffice, and we would need to see how the actual restrictions are phrased in other laws and whether or not they meet the standards that the directive provides for. Also, we would need to, well, some languages of some laws might suggest that the restrictions are actually in a way left for the data controllers to implement or to apply. And I think we would need to see whether more specific, more sectoral laws are making clear that there is actually a legislative framework that regulates that, and only for the data controllers to apply that framework. And finally, I promised to go back on the Article 18. That is this article which allows to regulate aspects relating to exercise of data subject rights in other laws. And what we see that some member states, not that far, it's not a general trend, but there are some member states who, when transposing Article 18, the language of the national law suggests that they actually wish to derogate from Chapter 3 of the Police Directive for the personal data which is contained in the criminal files on the criminal decisions. Again, without going into details now, I think we will need to see, analyze what are the implications of it. But going back to the rationale of the directive itself, it was not meant to be a derogation from the data subject rights by no means, but rather a possibility for the member states to regulate those rights within their criminal law legislation. And I will stop here, and hopefully the colleagues can expand.
Thank you very much, Anna, for giving us the legal landscape regarding data subject requests. Hielke, please. Could we have the slides, please?
Yeah. I do it standing up to make it a bit different. What I've tried to do is more to give a bit of an overview of this specific area. This is a specialized area of data protection. What I realized myself, I work in this area for years, that when I started in data protection, this was mainly the core of data protection. Everyone was extremely worried about access by governments to information, about police and justice profiling people, being, it was really the core of what was worrying people. And nowadays I see more and more a complete different trend, that we all are worried about what the big internet companies are doing, and this area tends to be a bit forgotten. But that's why I'm very happy to be here in this panel. Also see some old friends from the old days, like Daniel and Clara, with whom we were discussing these issues already for years and years and years. Let me say a bit something about this sector. This sector is a specified sector. There is no specific need why this is not under GDPR, but it is not under the GDPR. There are some legal reasons for this. There is, for instance, a declaration at the Lisbon Treaty of the Union, which said that this is an area which deserves specified rules. And it's also the practice and also the fact that the police may be a bit different and the justice may be a bit different. The term tailor-made rules is something which was quite often used, for instance, by Daniel here a lot of times, as showing that this is a different area. There is, I think, in this area a certain power asymmetry. There is a clear difference between what justice and police are doing and the individual whose data is processed. So this power asymmetry requires further thinking what kind of rules are needed to ensure that on the one hand we can have effective law enforcement, on the other hand that law enforcement does not disproportionately use personal data. And that's always ends up to quite specific rules. It also ends up to a basic thing that transparency, which is the basis of data protection under GDPR, that there are limits to this. Because if you perform an investigation, a police investigation, or just judicial investigation, it might not be very helpful if the persons who are under investigation, because they are suspected of a crime, that those persons are being, that they can have access to everything what's said about them. And that's one thing which is very important, and I think that's also what the directive does, clearly explained by Anna, limits must be necessary and proportionate. So member states cannot all do international laws to limit the transparency and to limit access rights. Access rights are one thing. Another thing is that with data processed in the context of investigation, there are also other elements of data protection law which are a bit more specific. And one of the most difficult things in this area I found is the idea of purpose limitation. If you collect data for a certain crime, for a certain investigation, can you then use this data also for similar investigations, similar crimes? A lot of discussion is there on that area, but the final answer, I cannot read it well in the new directive. I think there's still much open about this question, and if you think about how to protect people, it's one of the best ways to limit this is that if you have data which are collected for a certain crime, that they're not automatically also can be used in all kinds of other investigations against other people in other circumstances. There is another issue which I would like to shortly address. That's the split in the legislative structure. We have a lot of rules here. We have the GDPR, which applies to a certain extent also to processing in the area of police and justice. I will explain. We have the Europol regulation. We have the new regulation for the institutions here. And of course, we have different rules, specific rules, a bit outside of EU law on national security. Interesting of the Law Enforcement Directive, this Directive 2016-680, which we're discussing now, is that the split is based on the actor. So if a police or judicial authority processes data in the context of law enforcement, they are bound by this directive or the laws implementing this directive. However, if at the same time private actors are processing data or retaining data, for instance, data retention is an important issue, for this same purpose, they are still bound, they are bound by the GDPR. And that can lead to quite some complicated borderline legal discussions, and also can make it more difficult for individuals to exercise their rights, because it's not always evident that in what situation what law applies. So the split is based on the actor and not so much on the purpose of the processing. Also a little bit, but that was before. It's also important to know that private actors become more and more crucial in law enforcement. Those of you in this area working for some time, they always talk about PNR in this context. The fact that airlines, for instance, are obliged to send data they collected for traveling. They are obliged to send that, to give that to law enforcement. Data retention of telecommunications is another story and another issue, and that plays a big role now. I don't want to go into detail, but the evidence proposals, which are currently being discussed in Council and Parliament, are also an issue showing how important it becomes that law enforcement authorities, public authorities, have access to data which are in the hands of the private sector. So that's an important new element. Another issue is, if you look at it, that cross-border processing becomes more and more important in this area, because, as we all understand, crime is not limited to one member state necessarily, and also, let's say, telecommunications, use of data, etc., not either. consistency mechanism in GDPR I don't want to explain here because I don't have the time for that, but the question can be whether or not all these laws are clear enough and whether by not having clear rules we are good enough in terms of data protection. I don't have so much more to say, Mr. Chair. Profiling is always an important issue here. If you look at the speech, which I always advise everyone in this area, there was a very important speech given by Koen Leenaerts, the President of the European Court of Justice, on how they look at data protection, the clear wording everywhere was profiling. The use of artificial intelligence in all kinds of areas become more important. And when you think about profiling or also the use of AI, then you think about, at the same time, data subject rights. If the police at a certain moment or justice is using AI in the context of their investigations, how can people then still exercise their data subject rights? Questions where I don't have the answer, but it's good to know. Another thing, which I think is not at all implemented in this area, but it's part of the whole system, whole ecosystem, is the fact that data protection by design and data protection impact assessments will have to be part of the work in the police and justice sector. And that might really be very helpful if you want to protect individuals against indiscriminate or against unproportionate processing. The question, of course, is the practice. How quick will organizations change? I think, and those are my final points, I think what is very important is the novelty, I think, in the directive of indirect access. It existed in some member states, but now it's really part of the whole system, that if you limit subject rights, you still have to give indirect access through data protection authorities, already mentioned quite clearly by Anna. The role of DPA supervision, the role of the data protection authority is something which requires also some further thinking, because it's not so easy to play a role vis-à-vis police and vis-à-vis judicial authorities. They quite easily say, well, this is our area, we are the specialist here, and data protection authorities should stay a bit out of it. There are all kinds of difficult issues around European harmonization, not to be mentioned here, but it's important, I think, as well, the role of the EDPB. Finally, I would say the increased role of non-governmental organizations. We see a lot on that happening. We saw that a lot of complaints are being made, lawsuits are being made also by NGOs, but I'm not so sure that they were also very active in this area of police and justice. That's what I had in mind. Thank you very much, and see you.
Thanks a lot. Thanks a lot, Hielke. Vagelis, you're very, with suspense, we are expecting your contribution.
Thank you, Daniel. Does this, do I have to? Thanks. Hello, everybody. Anna and Hielke have presented the law. I will make I will be presenting to you 4 brief policy considerations, being based on my experience both on the DPA and in the lawmaking committee. Admittedly, Greece has not legislated in the field yet, so we will be getting some fury from Anna in the next weeks, I suppose, but we are getting there. So some policy considerations from my part. 4 points altogether. First point, please do not confuse the directive with the GDPR. The Law Enforcement Directive, although it came as a package under the data protection reform, is not the same as the GDPR. We do not have the same level of harmonization in the EU. The GDPR builds upon the 1995 directive, and this is first point. And second point, the market is more or less the same across Europe. So we have some direct marketing companies, we have social networks, problems are more or less the same. This is not the case with law enforcement in Europe. There are different types of criminalities, different needs, different structures of law enforcement agencies, a different field altogether. And while the GDPR benefits from the 1995 directive, this is not the case with this directive because the framework decision, as all of you know, did not do such a great job in harmonizing things in the EU. So please do not confuse the two. Although they come as a package, they're separate. And if you ask me, the directive, the Law Enforcement Directive, should be conceptually backdated to 1995. It is what it will do is what the 1995 directive did for Europe. So we have to, it's a different step as regards the two. The second point is that the directive, the Law Enforcement Directive, does not build in void because law enforcement agencies did not discover personal data processing in 2018. They have been doing this at member state level. The framework decision, as said, did very little in harmonization, so how have they been doing this? And if one lifts the lid upon such processing, then many interesting findings and perhaps unexpected may come. I need to point out that a lot of member states have data protection in the Constitution, so normally they should have legislated in the field at national level. I should point out the 1981 Convention that normally applies. And indeed, in several member states, the case is that they have used the rules of national data protection acts also in law enforcement fields, in providing, of course, generous exemptions in that to law enforcement agencies, but more or less the rules were the same. However, these rules, national data protection acts before the GDPR, were the rules of the directive, of the 1995 directive, which themselves were not drafted for law enforcement purposes. They did not have that in mind. So it's a mess. It is a mess and it is complicated. And each member state has to map the field and find its own way out. Not a very easy task. Third point, slowly coming to the subject matter of this panel, which is people's rights, data subject rights, DPAs themselves. Please do not consider that DPAs are multinational organizations of thousands of employees eagerly waiting to grab any new power that comes to their realm and anxiously waiting to exercise whatever new authorities they have. DPAs are relatively small organizations of a few dozen people normally, and to my knowledge, their budgets have not increased proportionately to the new authorities that the GDPR and the directive have thrown their way. So there is a problem there. There is a problem of actually doing what you are supposed to do. And for example, I will give you a trick of the trade, so to say, because I heard from Anna and both Hielke about indirect access of rights, of data subject rights by the DPA. Well, the direction we got at the lawmaking committee is please do not, from the DPA point of view, please do not add unnecessary administrative burden on us. Therefore, with regard to indirect access, the rule, at least in Greece, will be controller first, then DPA, not an either or. So data subjects, people will have first to go to their controllers, and if they do not make it, do not succeed in exercising their rights, then they come to the DPA, not first to the DPA. Just a trick of the trade to, maybe you will not agree to that, just a trick of the trade to minimize the administrative burden that the GDPR and the directive are adding on national DPAs, again, without a proportionate increase in their money or human resources. And my final point is what's been done already? How are people exercising their rights in law enforcement processing? Because, as said, this is not entirely new. Personal data processing has been taking place. So what's the story so far? To my knowledge, to my experience, 90% of of the cases that reach DPAs are Schengen related. This is a very specific process. It is streamlined, it is known, it is dealt with. And yes, most complaints, most exercise of data protection rights from data subject to DPAs are Schengen related. The rest, 10%, the point I want to make is that it depends on their lawyers. And this is also a distinction between this field and the field of the GDPR. This is criminal law. This is not GDPR, unsolicited spam, Facebook mistreated my profile, or even an employer has installed cameras on my workplace and now I cannot work properly. These, if you allow me, problems are dealt with successfully by the individual itself. The individual, if it does not want to lawyer up, can write a few paragraphs, address them to the DPA, and the DPA will take this further. However, this is criminal law. This is not direct marketing law. And people tend to get lawyers, to hire lawyers when they are faced with processing of their data by law enforcement agencies. Now, lawyers themselves, me being one of them, are very target-oriented, and criminal lawyers in particular have an end vision of a huge trial where their client will be gloriously released from all, acquitted and released from all problems. So they are using this as a tool to the end product, which is the trial, the criminal court trial. They are not, to my experience at least, they are not facing lawyers and clients and data subjects. They're not facing the directive on its own merit as a human rights instrument that is interested on itself, by itself, and for its own purposes on how data have been collected and further processed. They're interested as a tool to be used in the trial. So perhaps an investigation collecting data should not have has been conducted illegally. Perhaps data have been correlated illegally. Something to throw out the case to be used in front of court in the future. Therefore, we need to take this into account when drafting the national legislation implementing the directive. Its actual use on the ground, not on a theoretical level. Therefore, altogether, to come back to the question of this panel, is it an improvement or not? I would say that it is too early to say. To me, it is a starting point, and the future will tell whether indeed this has been an improvement on the individual rights or not.
Thank you. Good morning. Thank you, Vagelis. Well, it's true that law enforcement at national level didn't discover data protection now, but it's also true that what we had at national level in general was pieces of legislation, some of them by EU imposition, like for Schengen, Europol, customs. So I would say that the Law Enforcement Directive is like a last stroke in bringing data protection into the national law. And, of course, the exercise of the rights of the data subjects, which is a fundamental right in itself, in the Article 8 of the Charter. The way the rights are exercised in the law enforcement area is a very problematic thing. And experience told us that sometimes law enforcement, using the existence and justified existence of derogations in the law, use this as a pretext not to give access at all, even when there is no documented reason not to give access. So I would make one small question to each one of you. You'll have 1 minute to respond, then we go to the public. Anna, the first question is for you. With your experience, in particular, more recently with Schengen evaluations, where the rights are exercised and are monitored how they do, what is your experience? How member states and law enforcement authorities handle the rights of access and ratification, for instance, in that area? What is your experience?
Yes, thank you. So in terms of, like, say, experience from the Schengen evaluations, I can only say a very general remarks. And one thing would be that, well, the level of the data subjects actually exercising their rights is not so high, let's say. So in terms of the actual administrative burden that it is creating both on the data controllers and on data protection authorities, let's say, from the practical experience, I don't see that much of the pressure, to be honest. So that's let's say, the general remark. On how the member states are doing this, well, that varies. And also, I think in terms of the legislations, that varies. In a way, the Data Protection Law Enforcement Directive is now, in a way, providing some level of harmonization on how the data subject rights are exercised by, in a way, imposing that the data subject, that there is a possibility for the data subject to go to the data controller. Which was not the case, at least not in all member states. Some member states did not have that system at all, and they only went for indirect exercise of the rights. So in a way, it is also a comment to say that there is already, or there was already, a tradition in the member states to arrange things by giving a data protection authority a power and possibility to actually do checks and go into the systems to see the data and check lawfulness of the processing and ascertain that the processing was lawful and provide a meaningful reply to a data subject in that sense, even if when the restrictions is due, the data subject were not actually informed whether or not his or her data is in the system. The data subject was nevertheless reassured that if data was there, the Data Protection Authority make sure that is processed lawfully. I'm not sure whether that replies to your question.
Thank you. Now, Hielke, you raise very interesting issues, and we know that the directive was presented and was discussed as a package with GDPR, with its own features, of course, tailor-made rules for law enforcement. But there are some principles and new principles who were introduced in the new legal data protection framework, like the principle of accountability here. How do you see the principle of accountability in action in the law enforcement sector when all this web of justifications why the access rights or why the rights of the data subjects have so many derogations that has to be justified when there is a restriction, partial or total, of the exercise of the right, they have to justify. So how do you see the principle of accountability working within this context?
I think the principle of accountability, I think it's really important that it's now also part of the law also in this sector. It should work, I think, in different ways. One way, what I already mentioned, I think it's very important that data protection by design and data protection impact assessments, that they are part of the work in this sector as well, which give effect to this idea of accountability. Accountability means that you're responsible and that you're ready to show to data protection authorities and also to others that you take this all serious. And I think there's a lot to be done, but I think accountability can work a lot. And that the fact that there's exceptions to rights, exceptions which should be restricted, doesn't mean that controllers, also in this area, police and justice, that they're not responsible for what they do. So I think the principle of accountability, provided that there's some control that the data protection authorities take this serious, maybe also the EDPB could give guidance on what this specifically means in this area, can play a big role in my view.
Thank you. Now, Vagelis, for you, the practical implementation from DPAs. We all know that when laws in this area, in this case data protection, lands in a member state, there will be a change in the mindset of the law enforcement authorities, but maybe also it has to be a change in the mindset of some DPAs who are not so used, in some member states, not so used to monitor police. And the question here is always, do we look for a person whose data is processed always like a criminal in a very instinctive way? If the police has some information on the person might be a criminal, so maybe I won't mind, or I don't care, or I don't intervene in the same way as in other areas. Is this a risk? How DPAs can effectively perform their roles when, for example, the police says that that person has no access to the data because it would undermine an investigation, or one of those usual reasons. How do you think also the DPAs have their role in this important area?
No. Each case is it's judged separately and on its own merits. We benefit, at least in Greece, we benefit from the fact that senior judges, retired senior judges are members of the DPA, so we benefit from their wisdom and their experience in applying the law. So each case is it's judged on its own merits, and there is no prefixed mindset or prefixed ideas from our part. And yes, I think that we tend to apply the law in its separate case. And please also consider that, as I said before, each individual comes with a lawyer, because these are important cases, and I've seen cases where individuals stand by themselves for their rights, but not in this field. In this field, they hire lawyers who do their best, and there is a process where they come and explain things, and we hear them, and we come back to them, and we issue a decision based on the merits of their case. So nothing goes neglected, or no prefixed mindset on what the police may think or may not think. When it comes in front of us, it is a fixed file of a very specific case based on its own.
Thank you. Well, I was not referring specific to Greece. I was talking in general.
I'm using my experience on how we.
Yeah.
How
but for instance, some law enforcement officials argue that data protection authorities do not have the knowledge or the expertise, for instance, to assess the necessity of keeping the data. Because sometimes you have these kind of things. What would you reply to this?
We have to distinguish between general decisions and specific decisions. If we are talking about specific decision, about specific individual, well, the subject matter of this panel, data subject rights, then it is one individual coming in front of the DPA asking for something. And there, as I said, the case will be judged on its own merits. It's a completely different thing when DPAs have to assess on the necessity or lawfulness of a new system, of a new camera system, or a new, I don't know, whatever system the police or law enforcement agencies wish to implement, or already implement and wish to see whether they implement it or not. This is a totally different story. If we come to that, then yes, I would see that each agency, by definition, stands on different sides of the spectrum. DPAs protect the right to data protection, which is a fundamental human right, and therefore have to take a fundamental human rights stance on this matter. And law enforcement agencies stand on the prevention of and detection of crime. And it is normal that they will be asking, so it is a by definition struggle, whereby The DPAs will be looking to impose barriers, and the law enforcement agencies will be looking to get more processing capabilities in order to execute their tasks. So I do not see, I see a conflict, and people telling, one side accusing the other of not having enough understanding or not having enough competence, the same way that the police may conceptually accuse DPAs that DPAs do not have enough technical or crime prevention knowledge. DPAs could accuse the police that do not have enough fundamental rights knowledge. So it's a no-end.
Okay, thank you. Thank you, Vagelis. I just would like, before passing, so 2-3 minutes before passing to the public, to the audience, to take advantage of having Daniel here. I'm very old, so I knew Europol before DPO arrived. And I can witness that there was a huge difference after the Europol set a DPO office, and the culture in the organization changed completely. Could you share very quickly what was your experience as DPO and what are the main difficulties a DPO also face within an organization like a law enforcement organization?
Yeah, thank you for the opportunity. I mean, I would have a lot of points that I would raise now, but I will just 3 points also to echo that what other speakers said. So first of all, what we see at Europol, we receive data subject requests since '99. Yeah, last year we had 534 data subject requests in the organization. And they are not only from EU citizens, they come from all over the world to Europol. I think there is not one presentation that I gave in my career at Europol about Europol's data protection framework without a question about data subject requests. It is a topic that is of concern to citizens, to journalists, to parliamentarians. You will always get a question about how good are you in handling data subject requests at Europol. So 534 data subject requests per year maybe to some of you doesn't sound so much, but you have to understand there were old persons, citizens that were sitting down, writing a letter via the National Data Protection Authorities and saying, I would like to know what Europol has about me. And those citizens that are not in the database, they get a letter back from Europol, and it is important for them, saying, thank you very much, of course in the different words, but we got your request. We inform you that we don't have any data about you and the assistance. And for these citizens, it's very important to get this letter. And they get it within 3 months, because that is the legal framework. Now you say 534 data subjects, 3 months, that sounds doable. I think important is when you ask me about my experience as a data protection officer, and my unit deals with all data subject requests arriving to Europol, it is very important that you have a good governance in the whole process. From the moment the request arrives within the organization, authorized staff that does the checks in the systems, in all systems, because we have to check all our systems, that then prepares a decision of the director in the cases where there is in fact personal data stored on our system, prepares a decision of the director to answer that data subject request. And if we talk about accountability, and that is what we did in this panel as well, I think it's important that the law enforcement organization shows which processes are in place. And there, and I agree here with Vagelis, there is of course administration involved. That's clear. I mean, this is to answer data subject rights costs time, cost money, that's clear. But it is so important because it is important for the citizens. And therefore, for Europol, we put the question about the handling of data subjects requests as one of the prime issues when we talk about data protection implementation in our databases. One last point for me, because I would like also to support Vagelis, is also our impression of the last years. It's not just that the data subject requests, the numbers go up, although at Europol we had long years a good article about how we have to answer, not good from a fundamental rights point of view, but also doable from a law enforcement point of view. there are more and more requests coming to us via defense lawyers. That is what we see. Yeah, so they want to use it later in the case. That is clear, but therefore that is so important. And then then if they don't get the answer that they expect, then they go to the EDPS, and then we are in the question of indirect access. I stop here. It's the supervision that is responsible. They can then see the data, and they control then actually Europol or the Europol director about decision on the case for information that maybe doesn't even come from Europol, but is given to us by member states. So, but that gets too complicated. Has to do with Europol as a data hub for law enforcement information. Very, very last point, because you asked me as a data protection officer, a data subject request is always also a test on the data quality of the whole file. I said it this morning already in another panel. You might have millions of data sets, but you get one citizen that asks for access, and then it's only about name and surname. And if you then have non-accurate data there, if then is something wrong, I'm sure that the controller, at least in my organization, says, well, I know there's a lot of information in there, but with this data subject request, it is a data quality test for free, if you want, for the organization, because then you review what went wrong, actually. Thank you.
Thank you, Daniel. Now I would pass the word to the audience. Professor Raab? Yeah.
My name is Jesper Lund from ITPOL Denmark, a Danish digital rights organization. I would like to ask the panel to reflect on the value of indirect access from a citizen's perspective based on a specific example. So the Danish police, presumably like many other police authorities in Europe, keep a database of gang members or alleged gang members, because you do not actually have to be convicted of gang-related criminality to be in that database. It can be based on various intelligence sources. So if I ask for access to data about me in this database, so I would get we can either confirm or deny answer, because the legal framework in Denmark actually says that this answer will always be provided. So if I go through the indirect access route, and if I'm interested in rectifying any potential incorrect information, what am I supposed to do? Because the DPA doesn't know me. So the DPA really has no, I would argue, no possibility to see if this information about me is accurate or not, unless I provide, say, 40 pages with information that I have never contacted this or that person, I've never been in that area, and so forth. So what are citizens supposed to do in situations like this to exercise their data subject rights? That's my question. Thank you.
Okay. Thank you. Let's hear Professor Raab before, please. Thank you.
Thank you, Charles Raab, University of Edinburgh. I'd like to give a question to Hielke, because I think towards the end of your presentation, there were some points there which you didn't have the time to develop, and particularly the one about the very disorganized landscape of law enforcement and law enforcement organizations around Europe. I mean, if you take a kind of functional definition of law enforcement rather than an institutional one, there are all kinds of law enforcement agencies that are in the business of doing the kinds of purposes that Anna pointed out in her talk. In the UK, for example, we have 43 police organizations in England, 8 in Scotland, now 1 in Scotland, plus lots of other organizations involved in law enforcement. And I wouldn't generalize from the UK to the rest of Europe, certainly not at the current time, but it seems to me that if there is a kind of disorganized, non-standardized, non-coordinated set of arrangements, and therefore differences and inequalities in the treatment of citizens who are applying for who are making subject access requests. This is really not very good from the standpoint of fundamental rights. And I wanted you perhaps to say something about how you see the future. Do you see greater coordination coming, greater standardization, greater coordination, so that people can get their rights more easily when they apply for requests, they make requests?
Thank you.
think then I will, before you, I will try to answer the question of Charles Raab. I think this is a very useful, very important question, because when we think about the whole landscape of law enforcement, it's very varied. You have traditional police, traditional judicial authorities, but you have all kinds of other authorities which also do things which are exactly the same. And all those other authorities, and also private companies or public-private organizations, they are bound by different rules. That is a problem, I think, and that's a problem which we face a long time, and that was one of the reasons why when the GDPR was proposed, many tried to bring the also law enforcement authorities within the GDPR. For political reasons it was not possible, but I think that would have made sense. If in the future, and also let's say maybe more mitigated changes, for instance, we discussed the fact that Europol and Eurojust would be just part of the landscape of Dpas supervision with one set of rules, that now more or less is going to happen, but there are still different rules that apply. I know that Daniel thinks for good reasons, but you could ask yourself if in the long term that's good. The problem indeed, and that's exactly what you say, is the problem with these different sets of rules is that it's difficult for individuals to ensure to make their rights effective. That is a problem. Maybe we should also not exaggerate it, because the rights are, to a large extent, are similar, and I think it's important that people more and more start using their rights, and in that way there might be a way forward in protection. One last point, I talked before a bit about accountability. I think it's important as part of accountability that law enforcement authorities ensure that they work under the rule of law, that they respect the rule of law. And the rule of law means that they should also respect all these data protection regimes, and accountability can help there. I don't think I have the future in front of me, but you could say maybe that in a few years all data protection will be in one regime, but I'm not sure that's going to happen.
Thank you, Hielke. Vagelis, could you answer the first question, yes, about the exercise of the right in practice?
Thanks, Clara. No, I like the first question. Thank you for that, because it is a practical, so I can reply in a practical manner. You asked about indirect access to a alleged gang members database. So, by exercising in an indirect way your right, somebody from the DPA will visit, will check the database and verify if there is data about you in that database, and if yes, then if the database is lawfully being held, created, processed, and used. And you will get a reply on these two questions: if there is data on you, and if yes, if it is okay. I would say that this would be enough at this stage, because you will know if there is data on a gang-related database on you or not, and if it is correctly held. Now, you asked me about the content of the data, and how do you know which data are in there? Then my reply to you is that this is a gang-related database, organized crime-related database created by the police. So if they have data, so the DPA has checked already that it is operating okay according to the law. So if that database has data on you, then there are two options for you. Either it will come public through a criminal prosecution against you, you will know of the data and you will react accordingly, or nothing will come out of this, and you will be in no way harmed by a lawfully created and preserved database by the law enforcement agencies in your ordinary life. So I see that the right of indirect access in this case works.
If I may follow up with, so my specific sort of interest in this question was the situation where erroneous information about you is used to put
Yes, but you do
a
not
person-
know that, because if it is erroneous and it never ends to a criminal action against you, you do not really care. It is in a database that it's preserved, collected and worked for lawfully. The DPA has controlled that. So
Yeah, but
There
it
is
still it still
it's a
affects my
conception.
rights.
I can understand what Daniel said, that there are 500 people just asking, does Europol have data on me? And I can understand, but this is a theoretical question that has to be balanced, a theoretical worry that you may have as a concerned citizen that maybe I have some data in a gang-related database of the police. This is a theoretical problem that you may have against the state and public interest for your country to have a database on gang members and alleged gang members. So it has to be balanced. And indirect access, by verifying that yes or no you have it and yes or no the database is lawful, should cover it.
May I? I think you have a point there, because this is an imperfect way. The secrecy around the exercise of the rights turns that this is really an imperfect system. Anyway, that's why if the person, the data subject, doesn't have a clue about anything, because sometimes we have people that comes that they already know that there are data processed about them, and they have suspicion or they know that the data might be wrong. In that case, they exercise the right to rectify, and the DPA will have to be involved in that if it comes to it. But the checks that the DPA may, in face of a request, an indirect request, or now the indirect will go out, and it's just a second phase. But even when the DPA will be involved in that second phase, what the DPA has to do is not only to check if there is data there, but to check if the data is being processed lawfully. This means that the DPA, in the best of its ability, would have to check the origin of the data, if there was quality checks of the data. So there are a lot of actions. If a DPA performs its role well, there are a lot of things that minimize the risks of having mistaken data processed. That's why there are other requirements, legal requirements as to data quality. And when the DPA goes there, it has to check it all. It doesn't mean that nothing can go through this grid, of course, but it's an additional check. It's not just to go there and say, do you have data? Okay, I'll say whatever I can say. The DPA has to go further on. And in that sense, it will mitigate the risk. But of course, as you pointed out, the system is not perfect, and of course, law enforcement police has wrong data about people, and basically because they don't do the necessary quality checks, because they keep data much for longer than they are needed without revision. So there are a lot of flaws, and we just hope that with the Law Enforcement Directive, the situation might improve substantially. That's what we hope. So I think we are in our, if there is, I don't know, maybe no one else. Anna would like to just add something.
I mean, of course, the Clara and Vagelis, they are best placed to actually explain how the things are happening in practice. But in terms of, if the question is phrased, what is the value of indirect access, I think one should also consider what is the alternative. An alternative is to exercise only directly against the data controller and not having actual possibilities of checking the lawfulness that Clara just explained. And also as a general comment is that, also from experience of the Schengen evaluations, where there are indirect checks, we also see a number of decisions that follow up, which actually, for instance, require data controller to rectify the data. So in that sense, we see that there is a certain effectiveness of that type of means of exercising the data subject rights.
Thank you very much. I think that was also the end of our panel. Thank you very much for for coming, for attending. I started by introducing this panel and changing actually the title and asking, does it work? Yeah. I hope that we could give you at least some ideas from the different perspectives, whether it works. But one thing I know for sure, whether it works or not, has to be shown on each single data subject access request of law enforcement. Because when that arrives at the police, there should be a data protection officer taken care of, there should be an answer in the right time, and the checks should be made in the police already on this data. Each data subject request will show whether the system works. Thanks a lot. Enjoy the rest of the conference.